Court is now in session with your host, Peter Briggs.
Welcome to the Lawyers and Laypeople Podcast, a conversation-based podcast featuring interviews with some of Georgia's top lawyers, where we, in an easy-to-understand way, answer the questions on the minds of you, the layperson. In this podcast, we talk to specialists in a particular field of law to hear directly from them as to what clients typically ask them and what they should be asking. I'm your host, Peter Briggs. I graduated law school in 2006 from Georgia State University here in Atlanta, and have been practicing as a lawyer for almost 17 years. I'm a personal injury and bankruptcy attorney as well as a registered mediator. I'm excited to be joined by our guest today, Alex Simanovsky. Alex received his college degree in mathematics, graduating cum laude from the University of Georgia in 1992. He received his legal training at the University of Georgia School of Law, graduating in 1995 with honors. Mr. Simanovsky has devoted his entire legal career to helping Georgia's injury victims and Georgia consumers. He's a member of the Georgia Trial Lawyers Association and the American Bar Association and the National Association of Consumer Advocates. Mr. Simanovsky is the former chairman and former vice chairman of the State Bar of Georgia's Consumer Law Section. Alex can be reached at his website, filelemonlaw.com. Welcome to the podcast, Alex.
Hey, Peter. Thanks for having me.
So why don't you start off by telling our listeners what exactly you like about practicing lemon law?
Well, I like the fact that I get to help consumers. You know, I don't represent huge conglomerates. I represent everyday people in an issue that affects their everyday life. In the sense that, you know, obviously if you have a car that's not working, you can't go to work, you can't take your kids to school. I mean, it really has a major impact on people's lives. So I like the fact that I get to help people. And I like the fact that, I get to take on these big corporations who like to kind of try to get one over on the consumer all the time.
Yeah. So, I understand you file these not only in Georgia, but in other states. Can you just quickly tell us exactly like how many jurisdictions you wind up doing this in, and how is Georgia different than the other states?
You know, we do lemon law cases pretty much all over the country, not in every state. We're based here in Atlanta, so the bulk of the practice is in Georgia. And the good part about that is that Georgia has one of the best lemon laws in the country. It allows for the recovery of attorney's fees by the consumer. So ultimately, the representation is free to consumers. We don't charge any upfront fees or any out-of-pocket fees. We seek to recover all our fees from the manufacturer. That's it's one of the best aspects of the Georgia lemon law. You know, most states' lemon law, let's say, you know, you take a case and you get a buyback or a refund for a customer. Most states' lemon laws have a mileage deduction aspect to it where, you know, you have to pay the manufacturer for the miles you put on it. It's reduced, that reduces your refund. In Georgia, the mileage deduction is capped based on the mileage in the first repair attempt. So if you took your vehicle in and it had 5,000 miles on it, and it takes months for the case to complete, and then by the time the case is done, you have 50,000 miles on your vehicle, you only have to reimburse the 5,000 miles. That's really one of the biggest parts of the Georgia lemon law, is that it limits the mileage deduction for a consumer who ends up giving their vehicle back.
So you just threw some technicalities, and it leads me to my next question, which is, I can only imagine you get so many calls by consumers who are convinced they have a case, and they don't for whatever reason. So what is a prerequisite to having an actual good lemon law case?
Okay, well, that's a great question. And we do get a lot of calls. Mainly, we represent consumers with new vehicles, okay, that are under manufacturer's warranties, who have had either an unreasonable number of repair attempts. In Georgia, it's 3 or more, or an unreasonable amount of time or days in the shop. And in the state of Georgia, that's 30 calendar days, cumulative. So if a vehicle has more than 3 repairs or more than 30 days in the shop, then it meets the basic requirements for actually just making a claim, right? Obviously, there's not a guarantee that you're going to win, but that's kind of what we're looking for. We represent folks with new vehicles that are still under manufacturer's warranty that have had multiple repairs or an extensive, time in the shop. I mean, I've seen vehicles in the shop for 6-7 months at a time, which is pretty egregious. And in those cases, obviously, are fairly straightforward. Some other ones, maybe not.
Now, is there a standard definition for whether a vehicle qualifies beyond that?
No, not really. Like, all states have their own, statutory requirements. Some states you have to be in the shop for 4 or more times within a certain time period. And they're all different. In Georgia, you need multiple repairs, 3+ or 30 days within the first 2 years or 24,000 miles, right? That's how you meet the basic criteria. Other states is you got to be in the shop 4 times within 18 months or 18,000 miles. I can rattle off all the different state lemon laws, but they're all different. But the basic criteria is you have to have multiple repair attempts or excessive days out of service within fairly quick time period from the date of delivery of the vehicle.
And what sort of like official formal notice should a consumer be giving during that time? And does that, what happens? I mean, when people come to you, have they usually given the notice, or is that sort of what you wind up doing?
Usually people will just call me and they haven't done anything other than maybe talk to the dealership. They may have called the manufacturer's, 800 customer service number, right? Which neither of those things trigger, the procedural parts of the lemon law. In Georgia, once you have 3 repairs, you have to send certified note, or 30 days out of service. You have to send certified notice to the manufacturer, giving them, and it's a little, I can get into the weeds with this, but it's either this, right? If you don't have 30 days out of service, but you have 3 repair attempts, you have to give the manufacturer a final repair attempt. Okay. So after the 3rd repair attempt, you have to send certified notice, giving them one more chance to fix it. All right. If you have more than 30 days in the shop, you don't have to give them a final repair. And then you can just send a different certified notice where you demand a refund or a replacement. And then they have 20 days from receipt of the repurchase or replacement request to respond. Now, they don't have to respond, and sometimes they do, sometimes they don't. But after the 20-day period is then when you can actually file for an arbitration hearing. In Georgia, like I was saying, one of the best lemon laws in the country. In Georgia, they have a state-sponsored arbitration program that's administered by the Attorney General's Office of Consumer Protection. So we will file an application with the OCP, Office of Consumer Protection. They will assign a neutral arbitrator. And nowadays, obviously, everything is the hearings are by Zoom. Don't even have to be in person. That's much more efficient and much lower cost, and certainly much quicker than just regular civil litigation. Because you file a lawsuit, you get in front of a judge in about 2 years. In an arbitration process, you're looking at about 4 to 6 months process. So definitely much faster.
So I want to turn a little bit to things I'd imagine consumers may do before they reach out to you. How often does it come up that they just in good faith try to get the vehicle, they get frustrated with the dealership or whatnot, and they try to repair the vehicle themselves? How does that factor in? How often does that come up?
That doesn't happen very often, usually because of the cost aspect of it. Let's say you have a bad engine in your whatever vehicle, if you want to get it fixed yourself, it's thousands and thousands of dollars to put a new, either to take an engine out, refurbish it, or put a new engine in, or transmission, or and major components. I think it really just becomes cost prohibitive for a consumer to just, especially if their vehicle is still under manufacturer's warranty and the manufacturer is obligated to attempt repairs, at no cost. It's very rare where I see somebody who say, well, I just spent $10,000 fixing this. It happens, occasionally, but not very often. It's usually the folks then, they get more and more frustrated with the dealer, with the manufacturer. The dealers and the manufacturer's customer service is usually fairly lacking, and then they end up with me. And I can certainly, part of what we do, is we're in contact with the manufacturer right from the beginning, where we can say, hey, General Motors or Ford or whoever, send an engineer, to try to fix this vehicle. And then sometimes they will, and sometimes they won't. Sometimes the vehicle is just not repairable, which happens, and those cases then move fairly quickly through the process.
Now, what can be done if there's some defect that's not related to safety? How does that enter into the equation of a lemon law claim?
Non-safety related defects, are still covered by the lemon law. Obviously, safety related, there's special rules for safety related issues. Like when I was talking about 3 or more repairs or 30 more days out of service, if you're talking about a safety related issue, you only have to give them one chance to fix it. But, what is a safety related issue, right? It's a term of art, right? We can argue about, what is a safety related issue. So, I say anytime you're dealing with brakes, for example, my argument is that that's always a safety related issue, but I, often get pushback from manufacturers on that. But at the end of the day, it doesn't matter whether it's a safety issue or not a safety issue. If the law is basically, if it's a defect that affects the use, value, or safety of the vehicle. The use part is pretty easy. If you have a car that doesn't go, right, you can't use it, right? So clearly the use of it is affected, right? Value, that's also a fairly straightforward argument to make, is that, let's say I've taken my vehicle to the shop 5 times because I have a bad transmission or something like that. All of those repairs are on a Carfax report. So when you go to trade your vehicle or sell it to somebody, if that's what you're going to do, the dealer who's going to buy it or the person who's going to buy it can pull up a Carfax report and say, hey, why has this vehicle been in the shop 5 times for transmission? So instead of offering you $30,000 for it, I'm going to only offer you $25,000 because of the repair history. So that's a fairly easy argument to make on the consumer side. The value of the vehicle is affected. Now, so we talked about safety, and that's the easiest argument to make generally, is that, okay, I have brakes that don't work. That's clearly a safety issue. Or I have a vehicle that you're driving 75 miles down the highway and it'll lose power. It'll stall, right? Those kind of things, But the law, it doesn't really just focus on safety. It focuses, the language in the statute is use, value, or safety of the vehicle.
And just for clarification, when you're dealing with these lemon law claims, these are only for newly purchased vehicles. Is that correct?
Newly purchased vehicles. Now, most state lemon laws do not cover used vehicles. Georgia's lemon law specifically excludes used vehicles. All right. There are other laws that apply in that kind of situation. There's a federal, people call it a federal lemon law. It's really not technically a lemon law. It's called the Magnuson-Moss Warranty Act, which is the federal law that applies to any consumer product that costs more than $10 and has a warranty. So obviously, clearly applies to vehicles. It applies to televisions and, microwaves and I don't know, any kind of consumer products. But if we have a vehicle that for one reason or another does not check off all the boxes of a lemon law claim, like it's used or it's outside the mileage parameters, right? Because I was telling you, Georgia's 2 years or 24,000 miles. Let's say your problems with your vehicle don't start till 30,000 miles, right? You can't have a lemon law claim because you're outside the statutory parameters based on mileage. That's when we would make a claim under the federal law. The difference between a state lemon law claim and a federal warranty law claim is the damages, right? Under a lemon law claim, a successful consumer either gets a refund, which is basically all the money they have in the vehicle, less the deduction for the mileage, or a replacement vehicle. Under breach of warranty, under the Magnuson-Moss Warranty Act, the measure of damages is diminished value of the vehicle plus loss of use damages. So it's basically monetary damages as opposed to a refund. What in the industry we call it a cash and keep, basically where you get a monetary settlement and you keep the vehicle. The consumer then keeps the vehicle. Now, they don't have to keep it. They can sell it. They can trade it in. But a claim under the federal warranty law does not involve a refund or replacement in about 99% of the circumstances.
So where in the process do you typically get contacted, just on average, when, like after the first repair or when?
Usually not after the first repair. It's usually after, listen, we get a tons of calls, and we represented, a decent number of folks. We sign up a bunch of clients every month, and they're all slightly different, but I think on average, people will call us when it's been in the shop 3-4 times, or if it's been in the shop for a while. If somebody's car has been just sitting in the shop for 60 days on the first try, we'll hear from people like that. So it's hard to say, when people call us. Some people will call us prematurely, and then we'll educate them and say, hey, once you get to these thresholds, you can call us back and we can submit a claim. But most people who call us, are already to the stage where they've had multiple repairs or excessive periods of time out of service.
So if they contact you then and they've done the multiple repairs, like what exactly is covered in that initial consultation? Are you talking at that stage more about the arbitration process, or what exactly do you cover with them?
Well, we'll definitely cover the process with them. It's mostly just education, kind of walking them through the entire process. A lot of it is information gathering on our part. Obviously, the bulk of the case review is document review. So it's a lot of chasing folks down and make sure they have all the right documentation to send us. So the initial consultation is, like I said, it's education, and it's basically giving them a checklist, a to-do list. You need to get us, these documents, your bill of sale, all your repair tickets, copies of any communication, registration paperwork, any kind of documentation related to service or the vehicle itself. And then we do a full review of all that, and then make a determination as to whether we can help the client or not.
All right, and you touched on this earlier, but as far as attorney's fees go, that's just always covered at the end. Essentially, you're in a case determining at the beginning the likelihood that it's going to succeed, I guess.
Correct. Yes, it's basically a fee shifting provisions under the Georgia lemon law, and also under the federal law. Has fee shifting provisions which allow the consumer to recover, in addition to whatever the measure of damages is under either the state law or the federal law, is to recover the attorney's fee. So I never charge any of my clients any upfront fees. We don't take a percentage like in a personal injury case or something of that nature. The fee is contingent, obviously, on us getting a positive result for the consumer. But when we get to that point, then the fees are paid by the manufacturer on the back end.
So are the fees ever then an impediment to settlement because it's essentially an add-on to the manufacturer in addition to the repair cost?
Usually not. I mean, the manufacturer understands, what their obligation is under the law. They'll certainly try to negotiate the fees, and my position on something like that is I'm never going to hold up my client's settlement arguing over fees with the manufacturer for the most part. I mean, I try to make it where it's not an impediment. Our fees are not outrageous. These are not, huge fee cases, because usually they can be resolved, it depends obviously on how far we have to go in the process, but even on a pre-lit case, you're talking about, 10, 15 hours of fees potentially. And that's usually not a deal breaker for the manufacturers.
Yeah. So, as far as expenses to the client outside of your fees, I'm just imagining clients sometimes are like, hey, I had to go to the dealership 4 times. I had to find, a replacement car during that time. I missed whatever my kids' events, and I had to do Uber. They're just, in addition to just a general annoyance, just some of those types of things. Are those just uncompensated for?
The law's fairly strict in its interpretation of like what is, incidental and consequential damages on a lemon law case. Obviously, you have the cost of the vehicle, but if there's out-of-pocket repair costs, out-of-pocket rental fees, things of that nature, those are reimbursable, those are recoverable under the lemon law, but they kind of your general, what I would call pain and suffering type damages. I missed my kid's baseball game and he hit a grand slam and I'll never be able to see that. That stuff happens, but those kinds of damages are, not part of the lemon law, unfortunately. And I have to educate the clients all the time on that. They're like, well, I was aggravated and this and that. And I go, yeah, I appreciate that you were. I know that you were for a fact, but there's no pain. There is no pain and suffering in a lemon law case, unfortunately. I wish there was, because a lot of times, people are really put out by, not having a vehicle that works, like we were talking about earlier. In today's society, you can't do anything without a vehicle. Unless you live like in New York City or someplace like that, right? It's you can't live, right? You can't work, you can't go to the store, you can't do anything. So it certainly has a very major impact on our clients, and I appreciate that, and that's why we try to get these things moving as quick as possible.
So let's talk about the ones that sort of need to be litigated. Are these lemon law claims exclusively against the manufacturer, or there sometimes the dealer has some sort of culpability?
Well, under the lemon law, there's only the state law specifically excludes dealers from any kind of liability under the lemon law. It's basically only, pardon me, it's only as against the manufacturer, because it's basically a hybrid breach of warranty claim, right? So the manufacturer makes the warranty, right? The manufacturer directs the dealer as to how to fix these vehicles, right? So all the liability is on the manufacturer side. Now, are there instances where there are like other types of claims potentially against dealers? Yes, we generally don't handle dealer claims, but there's certainly issues of fraud that come up all the time, and especially with used cars. There's issues of like dealers actually damaging the vehicle while it's in their possession, right? That's not really technically a lemon law claim. That's potentially a tort claim against the dealer. We see that a lot. But as far as lemon law, that is strictly against the manufacturer.
All right, so let's talk about things that happen more often. Just talk us through the process from when you get involved until when it's ready to try to get it settled pre-suit, and then how often those do settle, and then if it's not going to settle and it's going into litigation, how long the litigation process is.
Okay. So just from the beginning, but I'll just kind of walk you through the whole thing. So consumer calls us, we get their information, they send us all their documentation, we review the case. Okay, it looks like a straightforward lemon law case. We retain them. Okay, so now we're at the beginning. The first thing that will go out is written notice to the manufacturer's legal department, putting them obviously on notice of the representation, putting them on notice of the claim, stating forth, what the defects are with the vehicle, why we, basically listing the prerequisites that have been met as far as number of repairs and days out of service. That goes to the manufacturer's legal department, and they all have, some manufacturers have in-house legal departments that only handle lemon law. Other manufacturers use outside counsel. It's different, but at the end of the day, I'm dealing with the same group of folks for General Motors, and I'm dealing with the same group of folks for Ford, right? Over and over again. So we'll send the demand letter, the notice letter, pardon me. It's also a demand letter. The manufacturer will then follow up. Hey, we got your claim. It's been assigned to Joe Smith in our legal department. and they usually ask for an extension of time. Because like I said, we were talking about the 20-day response window. They usually ask for an extension, and which I generally give them out of professional courtesy. And then the manufacturer will come back and they'll do one of three things, right? Once they've reviewed it on their end, they'll either agree with us that the vehicle qualifies under the lemon law, and they will voluntarily offer a buyback. That may happen about 10% of the time. Okay, that's one of their options. Obviously, another response that we hear from the manufacturer all the time is a denial. Like, no, we don't agree with you. We don't think that it qualifies under the lemon law, and we're not doing anything. That happens all the time. Okay, or they could come back. The third option, the third thing that we generally see out of these manufacturers is they'll do something in between, right? They say, well, we don't think it qualifies under the lemon law, but we're not denying the claim outright, but we're offering you, the consumer, X number of dollars in damages for your trouble, downtime, inconvenience, loss of use for the vehicle where you keep, the consumer then keeps the vehicle. And sometimes it makes sense for a consumer to take a cash settlement over a buyback. I'll give you one example, is in the instance of what we call negative equity, right? So if I buy a car and I trade in my vehicle to buy this new car, right? But the dealer, when I buy the car, let's say I owe $25,000 on my vehicle that I'm trading in, but the dealer only gives me $20,000 for a trade-in. So I'm rolling that $5,000 negative into the loan for the brand new vehicle, right? And so now if that brand new vehicle becomes defective and it qualifies under the lemon law, the refund may be a negative number due to the negative equity that's already built into the vehicle, right? And we see that all the time, especially, unfortunately with like lower income folks. They get really, pardon my French, screwed over a lot of times but in these transactions because the interest rates are out exorbitant. They have a vehicle they have to get rid of to get a new one, and the dealer takes advantage, for lack of a better term, and you have to roll in a bunch of negative equity into the vehicle. So if there's negative equity in the vehicle, that ultimately the negative equity is not the manufacturer's responsibility. They don't have to eat it, right? So there's a formula in the law that sets forth how do you figure out what the refund is, right? You take the purchase price of the vehicle, you add your sales tax, finance charges, you subtract a deduction for the mileage based on the statutory formula, and then you subtract the loan balance on the current loan, right? And sometimes when you do that math, it comes back with a negative number, which means that the consumer would have to pay the manufacturer that amount of money for the manufacturer to take their vehicle back.
And could they utilize gap insurance in that instance if they had it?
No, it's not, because the lemon law is not an insurable event. It's not like an accident or a theft or something that's covered. The lemon law is not covered under gap or really liability or any kind of auto insurance policy. We see that unfortunately all the time, and there's really not much we can do about that, except kind of change tack and say, okay, well, we can't do a buyback because it doesn't make financial sense. So we're going to try to negotiate a monetary settlement for you, to try to get them as much money for damages as possible. And that's a tough pill to swallow for some folks, but unfortunately, when you have a statutory scheme that's formulaic, it's like basically the law sets forth the spreadsheet for what numbers you plug in, right, and it spits a number out,
right, and that is the refund. And there's no negotiation on the amount of the buyback. It's just math at that point. You're just adding and subtracting.
Okay, so the ones that have had the denials and you've got to move forward, exactly. How does that process go?
Okay, well, there's two different ways to go about it, depending on kind of what's in the best interest of the consumer. One is lemon law arbitration. So, like I was saying, the Georgia Attorney General's Office of Consumer Protection in Georgia, they they have a lemon law department, basically, which manages and administers all of the lemon law claims. And so once you go through the prerequisites of sending the proper notices and things of that nature, then we file an application with the OCP, Office of Consumer Protection, and generally fairly quickly they will get an arbitration hearing scheduled. That's generally done by Zoom nowadays, and you can get a result. Generally within like 90 days of filing the actual arbitration application. Do they qualify or do they not? If the answer is yes, then the only other question is what does the formula say is the refund, right? The arbitrator's not going to award. The arbitrator's never going to say, well, I don't think it meets lemon law, but I think you, Mr. Ford or Mr. General Motors, need to pay them $5,000 in damages, right? Arbitration is it's an all or nothing deal, right? You win or you lose. Now, if you lose, then there's certainly, appeals processes. It's a de novo appeal to Superior Court, much like a appeal from a magistrate court judgment, right? But that becomes a full-blown Superior Court lawsuit at that point. And the only drawback for the consumer in that kind of scenario is that the law says that if the losing party at arbitration appeals and they lose the appeal, that party must pay the other side's attorney's fees. And that applies to the consumer and the manufacturer. So if I go to arbitration and I win my case for the consumer, the manufacturer, for whatever legal reason, and they're certainly entitled to file an appeal, right? And if they file an appeal and we go through that process, it's a bench trial, basically. A de novo appeal to Superior Court bench trial. And let's say we win again at that level, then the manufacturer's got to pay all the fees that the consumers incurred in defending the appeal. But it applies the other way too. If a consumer loses in arbitration and they want to appeal, but we lose the appeal, then the consumer has to pay the manufacturer's fees incurred during the appeals process, which could be pretty substantial.
And
so that
while this is all dragging on, the consumer's just driving their unreliable vehicle, right?
Yes, correct. That's the part, the most difficult part of this for the consumer is that they're stuck with this hunk of junk that they have, while the process plays out, right? Whether it's through arbitration, and obviously if it has to go to an appeal, then you're talking months, additionally, and there's no good answer to that other than, that they have to kind of deal with it one way or another. Most folks are not in a position to park a car and buy another one and then make two payments, one for a car that you have to drive and one for a car that's just sitting there while you're fighting over it. It's pretty unfortunate position for, a lot of consumers, but
I'd imagine for settlement, from a leverage point of view, the consumer's got, much more of a pain in the butt to deal with and more incentive to settle than the big old manufacturer who's not stuck with this car and's got all the money.
That's correct. And I have this conversation with my clients all the time, because time doesn't mean anything to General Motors or Nissan or Toyota or whoever. I don't mean to single anybody out, but time doesn't mean anything to any of these manufacturers, right? They're not going anywhere, right? Time, though, matters to a person who can't get to work because their car doesn't work, right? Or they can't, take their kids on vacation, whatever the case may be. So it's a little devious, I guess, but the incentive from the manufacturer side is to drag it out, because at some point the consumer is just going to say, well, I have to do something, right? I can't wait another 6 months, right? So I'll take a cash offer, from the manufacturer. I'll take my car, I'll go trade it. I'll use that money as a down payment to get into something else. And that, listen, you're talking about, Joe Average fighting against a multi-billion-dollar international conglomerate, right? It's really not a terribly fair fight on the front end. But we try to level the playing field as much as we can, kind of given the constraints that are there.
Yeah, I've dealt with this in my personal injury cases. The closer you are to trial, the better your chances are getting a better settlement. Time
Correct.
is, never really on their side. So before I let you go, I do want to know,
Sure.
how many of these kind of cases do you handle a year?
We generally handle about, 12 to 1,500 cases a year.
Wow.
Yeah. I mean, we have a pretty, it is a volume practice, and, we're one of the bigger lemon law firms, but there are other firms out there that'll probably handle 3,000-4,000 cases a year. There's some guys in the Northeast and out West, who do crazy volume. It's almost, just from a practice management standpoint, I don't know, managing, 1,500 cases a year is a pretty big job. I can't, to try to manage 3,000 or 4,000 I would pull, the rest of my hair would fall out.
Well, I want to thank our guest, Alex Simanovsky of Alex Simanovsky and Associates, for joining us on this podcast, and to thank you for listening. You can find Alex at autolemonlaws.com. That's autolemonlaws with an S at the end.com, or filelemonlaw.com. That's filelemonlaw.com. You can visit me online at brickslaw.com. That's BRICKSLAW.com. You can also rate or review us wherever you get your podcasts, Apple Podcasts, Stitcher, Spotify, Google Play, or wherever. All of our contact information can be found in the link below. For more details, please email me personally at peter@brickslaw.com.